All right. Well, there you have kind of in honor of Halloween, as we were talking about earlier, Socialism 101 slide, Socialism for Dummies or Socialism for Kids, how to explain socialism and make it understandable for kids. So there you have that slide. Anyway, on we go to a new subject today, but first need a couple things actually. First of all, do we have anybody here who's in New York? We do actually. Abby, aren't you from New York? You are indeed, right? Do you have a working mic today? Because I need to draft you. Yes, all right. And then my next question would be, do we have anybody near Indiana in class? We were probably Logan, you're the closest one, being from Michigan, right? Do you have a working mic? Why do I ask for New York? You will see later in class. Let's see, Logan. Yoo-hoo. Are we doing the slide thing today? I don't know what the slide, you mean with the pictures? No, that'll come next week. Logan does not, what? Logan, no working mic? That is not good. All right, then I must keep looking. Has anybody ever visited Indiana? Anyone? Abby has. Well, but you're my New York person. Well, we could do this. Hannah, you are from New Jersey. That's like right next to New York. Do you have a working mic today? Logan has ordered one. Nice. Okay. Hannah does. Okay, great. So Hannah, all right. Hannah is going to be our New York person, which will make sense later. And Abby, since she has visited Indiana, is going to be our Indiana person. In fact, isn't that funny? Well, you know what? If Hannah, if you visited it, since you're only from New Jersey, I'm going to make you the Indiana person. And Abby, you're back to being the New York person since you're actually from New York. Does that make sense? It's complicated, but if you're following me, well, only I need to follow me. So I've got it. And then how about if we have Mark? Mark, do you have a working mic? I just need you to read something a little bit later, or actually come on board. I don't know, either read or answer some questions or something. I can't remember right now. Anyway, all right, good. So we've got that later again. I'll kind of fill in the details later. All right, let's talk about the homework. Homework's going to be a little bit different today. The good news is you have no quiz today. Woohoo! Of course, the reason you have no quiz is because you have a paper to write. Come on, every government class in the universe, you have to write a paper during the semester. So if you're not a quiz person but more a paper person, you will like this. So anyway, we'll talk about the paper in just a second. But just as a reminder, keep memorizing. Don't forget to send your pictures. Again, thank you to Mark, Sarah, and Hannah, and a partial thanks to Brooks, who sent the information without the picture. All the rest of you, get it in immediately, because this is like your last chance. Next week, we're going to press. Next week, you're going to be meeting your classmates, okay? So do that. I did mention to you last week you had 2 weeks to see the view, to look at the Session 6 video entitled The American Presidency 2. So if you didn't already do it this week, because it's now due next week. And then midterm, that just tells you that we're going to be preparing for the midterm next week. And so that'll be your homework next week, okay? You don't need to worry about that now. That's just kind of telling you what is coming, okay? All right, let's talk about the paper, since that is and thank you, Julia, for that reminder there. Let's talk about the paper. Read the file entitled, and this is in your study place, the file entitled 42 Abortion Clinics Closed in 2013. Then write a 450 to 550 word letter that you could send to a state senator or representative. Now, I'll probably say this a few times. It's your state senator or representative, not your U.S. senator or representative. In other words, it's your representative that represents you or your family in your state capital, not the one that travels to Washington, D.C. And by the way, the word limit, you will obey the word limit. If you're 2 words, you'll get points taken. In your words, you will get points taken off. Although, let me give you a caveat. If you are verbose and you like writing, it's just hard for you to shrink what you're saying. It is more important that you cover everything that you need to cover. Okay, so don't say, oh, I've already gone over the limit and I still have stuff that I need to say, so you know, I'm just going to stop writing. It is much more important that you cover, and we're going to talk about it in just a second. You see the 1, 2, 3, 4. It's really important that you cover those 4 points. Now, you try to say it as succinctly as possible, and many of you will be able to do that. Okay, so you know what? I just want to, you know, I'm trying to be fair and alerting you ahead of time that there is point deduction, but believe me, it's not as great a deduction as not saying things that need to be said. Okay, does that make sense? So here's what the letter is all about. The letter should inform your legislator about what these states are doing. That's mentioned in the article, 42 abortion clinics closed. And then ask your state representative or state senator what similar efforts have been made in your state. Okay, so that's one thing that your letter is going to ask, and you can do that very briefly, because here now is the main part. If you go under or over, you get points off. Yes, Sierra. Over or under, you get points off. But having said that, if you go over, I would actually rather you go over and cover these 4 points than like only do 1 through 3 and say, oh, so I can't go over, so I'm going to skip 4. In other words, there's heavier point deductions for not dealing with these 4 points. Now, this is the kind of you'll actually like this, because I actually give for you what it is you need to write about, so you don't need to spend half the week trying to decide, okay, what am I going to write on? I mean, it's given for you, and I tell you exactly what I'm looking for. Okay, so number 1, again, you're going to be asking your legislator what the state's what his state has done in terms of efforts to shut down abortion clinics. Now, you know what happens is immediately state legislators will come up with excuses. Oh, we can't do that because the Supreme Court has spoken in Roe versus Wade, and things like that, and so our hands are tied, blah blah blah. Basically, what you see there on the screen, 1, 2, 3, and 4, is answering objections that your state legislator might throw at you. And by the way, I don't think I've mentioned it. You don't have to actually send this letter to your state legislator. I want you to address it to him or her, but you don't have to actually send it. Now, you do have to submit it to me, okay? But you don't have to send it to your state legislator. Nevertheless, we're using this as an opportunity to apply some of the things that you've been learning as if you were writing to your state legislator. And I'll say this, probably about half of my students do send it to their state legislator. So that's fine too if you do. Yes. Can you send it to him instead of? No. Now that you cannot do, Abby. You do need this because, well, I mean, you could, but then you get a 0. So you probably don't want to do that. All right. So here we go. You're answering objections now that your state legislator will probably throw at you. So when they say, the Supreme Court has already dealt with this and our hands are tied. Well, number 1. Explain why Supreme Court decisions, such as Roe versus Wade, are not the supreme law of the land. Remember how Chapter 2 mentioned that there are 3 things that are the supreme law of the land, right? Supreme Court decisions were not part of that list, okay? It'd be good to go back to Chapter 2 and look at those 3 things in the Supremacy Clause and point out to your legislator. Yeah, you can give examples from the book. Absolutely, Sarah. Yeah, in fact, that's what this assignment is getting you to do, is to really apply what you've been learning. So you don't really need to go elsewhere looking for stuff. This is more like, okay, you've learned it. Now you're going to apply it by writing it down and formulating your arguments, okay? So one is when you're pointing out to your legislator what the supreme law of the land actually is, those three things, and what it is not. Okay, it's not Supreme Court opinions. All right, number two, and this may sound similar, but it's a little bit different. Show why the Supreme Court is not the final word on what the Constitution means. And you're going to be reading about this in Chapter 6. One of the greatest ways that you can make an argument, and you learn this in logic, is to appeal to authority. So you can appeal to authority here by pointing out how, and give examples of where founders said that each branch of government is independent of the other branches and can interpret the Constitution for itself. Okay, so you're going to be reading about that the Supreme Court isn't the final word. Each branch is independent of the other branches. You could talk about how the founders, like Alexander Hamilton, said that the Supreme Court can't force Congress or the president to follow its opinions. You can see that on page 95 of the book, where Alexander Hamilton is discussing this in Federalist Paper 78. So those are ways that you can flesh out number two. You're actually going to be reading about that this week. Number three, give historical or recent examples. Notice the S on examples, historical or recent examples. That S means, and hopefully you know this from grammar class, that means more than one, right? Example would be just one. Examples means more than one. And even though I've emphasized this like this, still some of you will only give me one example and you will be docked, okay? So give historical or recent examples to show how state officials have protected their citizens from unconstitutional federal action. So you go back to chapter 4 in the book to get examples. You've answered questions on this. But see, understand how this too is helping answer a state legislator's objection. When he says, oh, the court has already decided this, I'm just a state official, we can't do anything. Well, no, you're going to now maybe give him examples of things that he's never heard about. Historical or recent examples showing how state officials can interpose themselves. Okay, so you following that? Hopefully that makes sense. And then number four, discuss constitutional arguments. Take a look at page 62 and 63 in your book that show why the states can interpose themselves, why the states can do what you're saying in number three. By the way, you don't need to list 1, 2, 3, 4. This is, basically each one of these would just be a separate paragraph. But discuss constitutional arguments to show why the states can interpose themselves. And you can get extra points and spruce up your argument with what Jefferson and Madison said. Take a look at pages 71 through 74. I should note that this number 4 requirement is where kids do the worst. Because sometimes, actually a lot of times, you guys will just want to throw like certain constitutional provisions out there, like you just mentioned them in passing, as if your state legislator is going to understand what that means. No, connect the dots for them. First of all, explain the constitutional provision, and then explain why the constitutional provision is actually justifying this whole concept of state interposition. So again, connect the dots for them. That's again, in logic, that's you don't just throw stuff out there and expect people to understand it. Connect dots for them. That's really important. Okay. Now let me give you a huge caution or warning about your letter. And I already mentioned this. Well, actually, I didn't mention this first part. Sometimes sometimes seen where students, maybe they did like a paper already on abortion or something like that, so they want to turn the assignment into a general opposition letter against abortion. Now, I certainly don't mind you speaking your mind on the abortion issue, and using facts and figures, but realize that's not the main focus of the assignment. The main focus of the assignment is doing those 4 points that I just went through. Or look at it this way, and look at the second paragraph here. 3 things to keep in mind. Your letter should briefly inform your legislator, and literally you can do this in 1 or 2 sentences, about what those states are doing in regard to abortion, what they're doing. That's in that article I've uploaded for you. It'll show them in 1 or 2 sentences, just show them what's happening, why abortion clinics are being shut down, okay? So you can just do that briefly in your introductory paragraph. Number 2, ask your state legislator in just a sentence, maybe in the intro or in your concluding paragraph, hey, what's being done in my state, okay? Because that's kind of the impetus for why you're writing this letter. You want to know what he's doing or what's being done in your state. And then number 3, make the 4 points that are mentioned in the previous slide. Okay, I'll go back one there. Those 4 points, so that can be 4 separate paragraphs. So you have an introductory paragraph, and then you have these 4 paragraphs, 1, 2, 3, 4, and then a concluding paragraph. So basically 6 paragraphs is what your paper would look like. And again, it's 450 to 550 words. Now, take note of this. If you took really great notes on everything I just said in discussing the previous slide, and you apply this well in your letter, you will do fantastic on this assignment and get a good grade. If you ignore what I said or didn't get it all down, then maybe you want to listen to the recording and pause it to take notes and things like that, because the stuff I gave you on that previous slide and examples are going to be really helpful for you. Okay, and of course I'll put all this in a review or a review of all this in the messages slide. Okay. Now, how do you find your state representative or senator? Well, your state representative or senator, as I mentioned, works in your state capital. Don't address it to your federal representative or senator who works in Washington. All right. And then that, you see that URL there? That will allow you to easily figure out who your state legislator is. Now, it's also going to show you your federal legislators, so don't choose them. Choose to address it to your state representative or senator. Any questions on that? Any questions on that? Again, you can always review the recording or take a look at in the messages slide. That may clear up, as you're getting into it and you're thinking, okay, wait a minute, what did he say? So you can always review it that way. And then let me remind you of 2 last things. As always, include your name and section number. Now this time I'm adding one more thing. Put the word count in the Word file. If you don't do that, you will get docked. Okay, anything that I'm requiring of you here, if it doesn't get done, I'll dock you. So please make sure you put the word count. When I say the word count, don't count, the dear so-and-so or anything else that you've got going on, like your name and the section number. Don't count that. No, just count the actual words in the letter. Okay? And Sarah, yes. Thank you for asking that. If you're not currently inside the United States, either choose where you were born or the last place you lived and just use that zip code to look up your state representative. And then finally, as a last reminder, don't forget to send in your picture. No, that's not pictures that you're going to see. Those are my 3 oldest children there. Although this picture was taken a long time ago, because those 3 are my 3 married children now. They're all very close, as you can see in the picture. Although they were like trying to be like, we had just finished taking Christmas photos, and we were all like happy and laughing, and then they were like, okay, let's do a serious picture, and they did this like the what's up, kind of picture, So anyway, it kind of came out cute. So, but yeah, they're my married children. So as you can see, this is a quite a long time ago picture. Anyway, so please send your picture to Julia. Yes, the cool kids are back. The one on the left is just going to be moving to Michigan now. He and his wife, they've been living here for a year or two, and oh man, our hearts are tearing. We're going to miss them tremendously. Yep, so he's coming near you, Logan. Well, at least closer to you than anybody else. He's going to be. They're going to be outside the Toledo area. Where are you again? Bad idea. Well, actually, his wife loves the cold and driving in the snow, and my wife would not like it. Near Lansing in DeWitt. Okay, I don't know where that is. All right. Well, let's get cracking then. Let's get on with our subject matter because we're running a little bit behind. So let's start with the theme. Remember what the theme is to this class and our founding documents? The theme was it's important to limit the power of civil government. You all remembered that, right? Right? It's important to limit the power of civil government. So how do you control or limit the civil government? Well, Madison answered that question this way. In the compound republic, that's one way, of America, the power surrendered by the people is first divided between two distinct governments, okay, that's federalism, and then the portion allotted to each subdivided among distinct and separate departments, that's separation of powers. Hence, the double security arises to the rights of the people. The different governments will control each other at the same time that each will be controlled by itself. So, we've talked about that in previous classes, and so you have the three things that he mentioned there: republic, federalism, and separation of powers. Now, with federalism, we've talked about this. This system of government can check the tyranny of the majority. It helps check the tyranny of the majority. For example, take the issue of abortion. Legislators could ban abortion irregardless of what the polls say the American people think. I mean, even if 51% of the people or 90% of the people supported the murder of the unborn, legislators could still overrule them and vote to ban it, because we are a republic and the legislators don't have to take polls of the American people to decide what laws they're going to vote on. Now, because we're a democratic republic, yeah, I mean, that could mean that voters vote out legislators, if but irregardless, legislators could, in fact, we would probably see in a lot of places, voters would probably be happy with that. But again, that shows that we're a republic where legislators make the laws. We're not a democracy. It's interesting. In South Dakota, the legislature actually banned abortion 9 years ago. In 2006, they actually banned abortion. Although later, we'll see what happened. We'll see that later in class. Brooks, when you say was that in the book, was what in the book? Are you talking about the abortion example? The abortion example was not in the book. The James Madison quote. Yes, that was earlier in the semester, or earlier chapters. It was in the book, yes. And we've also dealt with it in class as well. Anyway, so we'll see what happened. Later on, we'll see what happened in South Dakota. We'll see, sadly, what happens when we depart from a Republican set of principles and start acting like a democracy. But anyway, we'll get to that. So point number one, a Republican form of government is a great check and balance. It helps check the tyranny of the majority. Secondly, federalism, and we've spent a couple weeks talking about federalism. State officials can check the power of national officials, and you'll be dealing with this in the paper or the letter that you're writing. We saw this principle established in the resolutions drafted by Virginia and Kentucky in 1798. Those two states were challenging and opposing the Alien and Sedition Acts. And so that was a real good example of federalism in action. And of course, there were a lot more examples, more than just the Alien and Sedition Acts. But anyway, that's point two, federalism, where states can check the power of national officials. And then number three, thirdly, mentioned in Madison's quote, separation of power. Different departments of war, each of them checking the departments. Now, regarding the separation of powers, basically there are three powers of government, right? What are they? What are the three powers of government, which you read about this past week? Don't be shy. You should know what these are. Legislative, executive, and judicial. That's right. And by the way, where do you think they got the ideas for these three powers, or maybe separating these three powers like this? If you answer the Bible, advance to the head of the class. Yes, indeedy. The Bible, take a look at this passage. For the Lord is our judge, the Lord is our lawgiver, the Lord is our king. It is he who will save us. Notice, God exercises all three powers. Now, to put it quite bluntly, it's okay for God to do that. It is not okay for one man. God is perfect, right? So he can exercise these powers, as we say, flawlessly. What's the problem with giving these three powers to one person or one set of people? What's the downside of that? Tyranny, right? Because man has this sinful nature. Yeah, as Julia says, we're broken. We do what we want. Abby says we're sinners, the S word, right? So that's why the theme of limiting government power is so important. That's why the theme of separating the powers is so important. Now, let's see. Earlier we agreed Mark would come on to read something and answer a couple of questions. So Mark, you got you on the line. How's it going?
I'm going well. Yourself?
Doing okay. Our resident Giants fan. I also have a boss who is a Giants fan, so I need to be very careful what I say about the Giants. Anyway, why don't you read for us what Madison says here in Federalist 47, and then tell us what he's saying is the very definition of tyranny. So go ahead.
Okay. The accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny.
Okay, so Mark, stay with me. Oh, okay, go ahead and answer what you were going to say.
Okay, so Madison was saying how the tyranny is defined as when one person or a very few people have all three of the powers that we have mentioned, judiciary, executive, and legislative. And he pronounces that the very definition of tyranny.
Okay. Thanks, Mark. I'm going to bring you back in just a second. I muted you because we've got a little feedback whenever I talk. But you read about the Pharaoh in Exodus chapter 5, right? You all read about that. And in your notes, you can just skip the 3 Exodus slides. That's there for your use to take notes and things like that. But let me come back to Mark. And Mark, I would like you to explain for us, how did Pharaoh exercise first legislative power, then how did he exercise executive power, then how did he exercise judicial power? So go ahead, take it away.
Okay, so when the Pharaoh said, we will not give you straw to put in your bricks, That was a legislative act saying how we are not going to supply you with straw and you will use bricks or have to collect your own straw. That was legislative. Executive was when he put that law into practice, such as punishing the people that went against that law by flogging them and punishing them like that. The judicial part was where he interpreted his own law. So he was saying how, let's see, I can't remember exactly, but he was pretty much acting as his own judge, judging on whether his law was right or not.
Okay, very good. And just to help you out on that last point, he was interpreting the law. That's true, but he was. You remember he was hearing the complaints of the people, and thereby, interpreting the law and applying it. Of course, not in their favor. But you can see how difficult it would be. And by the way, excellent job on summarizing how Pharaoh was exercising these three powers. Can you see how difficult it would be if the person that you're appealing to is the same one who made the rules and the same person who's been enforcing them? I mean, today, what do you call that? When the same person hearing an appeal is the same person making and enforcing the rules. What do you call that? You call that a parent, right? Ha 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 ha! I know parents that are listening right now are like, Mr. Pratt, I'm going to get you. Now, wait a minute. On behalf of parents, of which I am one, there is a big difference. Government bears the sword. Parents don't. And that's what makes it so dangerous for government to exercise all three powers, right? I mean, in Egypt, all three powers resided in one person, and that was scary. But that's the beauty of the separation of powers in the United States Constitution. Not any one person is supposed to exercise all three powers, and each branch has the ability to check and rein in the others. Now, in Egypt, again, Pharaoh exercised legislative power, as Mark was saying, because he made a law or a rule which ordered the Israelites to collect their own straw, right? Well, in Article 1 of our Constitution, we see the legislative power being granted. That's the section that deals with the Congress. They're the ones that exercise legislative power. They make the laws. They are supposed to only pass laws that are authorized by the Constitution. But as we've been talking about many times already in this semester, there are many times when Congress exceeds its authority. Take the health care legislation that was passed and enacted in 2010. When we looked at Article 1, Section 8 a couple weeks ago, was there any authority, for Obamacare, for health care? I mean, we even saw a representative who, when asked about that, remember, said, well, there's actually a lot of things we do that aren't authorized by the Constitution. I mean, if the Congress can force you to buy health care, which is what Obamacare does, imagine if they forced you to buy other things which are good for you, like vitamins. I mean, vitamins are good for you. Vitamin sellers would probably love a law like that. Or how about hats? I mean, probably all of you don't wear hats. Maybe some of you do, baseball caps or whatever. But, hats can keep you from getting skin cancer. So why shouldn't we be required to buy hats? Or vegetables. I mean, how many of you just absolutely do not like vegetables? Well, what if Congress forced you to buy them and eat them because they're good for you? They forced you to buy a particular broccoli every week. That's right. Well, that takes us to our next slide. I love this article. This is what one author said in comparing broccoli with health care. Can President Obama and Congress enact legislation that orders Americans to buy health insurance? They might as well order Americans to buy broccoli. They have no legitimate authority to do either. Yet neither Obama nor the current leadership in Congress, now this is back in 2009, 2010, of course, neither seems to care about the constitutional limits on their power. So you see what he's saying? I mean, what's the difference, right? I mean, if Congress can force you to buy health care, then why not broccoli, and heck, while you're at it, buy VeggieTales too. I mean, those are good for you. It's good for the soul, right? So back to the separation of powers. What could the other branches do when the Congress steps out of line? Let's say Congress passes a bill. We want to force everybody to buy health care. What could the president have done? Now, granted, Obama didn't do this because he was the one pushing Obamacare, which, people name after him. But what could a president do if Congress sent him a bill that exceeded their constitutional authority? What could in our system of separation of powers, what could the president do? Get out the red pen and send it back, right? Isn't that the V word? Not victory, but veto. Veto. But that's not the end of the story. If he vetoes it, what can the Congress do? And this is yet another check and balance. So it doesn't allow the president to become a dictator. They can vote against the veto, what we call overriding the veto. What percentage? Very good, 2/3. I know a lot of times people say 3/4, but it's 2/3. And we love to talk about this. This is like the prime example of checks and balances or separation of powers, and yet it doesn't happen a lot. George Bush was president for 7 years before he had his first veto override. 7 years. Obama, first of all, has rarely vetoed legislation because people in the Congress are wimps and they won't send him stuff that he doesn't like. He's only vetoed 4 or 5 bills. And of those that were vetoed, none of them have been overridden. So Obama has been president now for 7 years, and he has yet to have a veto override. So anyway, but there you see the give and take, or the check and balance between Congress and the president. Now, let's say Congress passes a bill, the president signs it. We still have a third a third branch. What could the courts do in exercising their check and balance power, their power under separation of powers? What could they do? The dramatic pause is allowing for you guys to answer. Okay, there we go. Declare it unconstitutional. Good. That is one thing they could do. They could say this is unconstitutional, and so we're, as a result, that would mean anybody who was being prosecuted for not following it, they would not be convicted. If the court said this is unconstitutional, we refuse to convict, that effectively vetoes, as long as you have that current court makeup, we don't use the word veto, but that effectively vetoes that law if the courts are refusing to convict under that law. Does that make sense? So there you see some of the give and take ways of overriding and reining in what the Congress does. So that's Article 1, and not that all these things are necessarily mentioned in Article 1, but Article 1 deals with the legislative power, and in the Constitution we see that ways that the other branches can rein in or serve as a check and balance to the Congress. Now, Article 2 deals with the executive power. So we've looked at Article 1, Section 8, the legislative power. Let's go to the second one, the executive power in Article 2. The executive department enforces laws that have already been enacted, and that's very important. They're only supposed to enforce laws that have been enacted. For example, let's say Obama doesn't like those pesky homeschoolers because they tend to grow up and vote not to support policies that he likes. Most homeschoolers tend to be fairly more conservative than he is. So let's say he's devised a way to get back at them or to curb the power of homeschoolers. And so he starts throwing homeschool parents in jail. Yeah, those rotten homeschoolers. But there's no law saying it's illegal. Well, let's say he starts incarcerating homeschoolers. If he did that, what could the Congress do to, as part of their separation of powers, what could the Congress do to rein in a rogue president? What could they do? Good. One power they have is impeachment. Now, I will say up front, it's a hard thing to do. No president has ever been both impeached and convicted, thus removing them from office. So the closest you might say they've come is with Nixon, because they began impeachment hearings and then he resigned. I mean, he saw the handwriting on the wall, as they say. A couple of presidents have been impeached but never convicted, although they came close with Andrew Johnson. So the point is, the president just can't do anything he wants. Can a president just go to war? Can he just start, declaring war against NATO? I mean, I know sometimes presidents act like they can, but no, they can't. What has to happen first? What should happen first before a president goes to war? Again, this is part of our separation of powers. Who declares war? Constitutionally. The Congress, right. The Congress does. So, if and when the executive department exceeds its authority, what can the Congress do? Well, one thing is impeach, which you guys mentioned. But another thing they could do is pass legislation to overrule the president. They can pass legislation to overrule the president. Let me give you a great example. Actually, this happens a lot. Now, you would think, oh, this would be hard to do because the president would veto it, but congressmen can get clever in how they do this. And I'll give you a great example of this. And actually, this is something that the organization I work for, 9 to 5, this was something that we were heavily involved with. But back during the Clinton administration, that administration all on its own decided to start taxing every gun purchase in the country. Now, this was back in 1998. They decided to do this without any constitutional or legislative authority whatsoever. So the Congress got involved. I work with Gun Owners of America. So Congress took action, and they passed an amendment offered by Senator Bob Smith of New Hampshire to defund, that means to cut funding, to defund the ability of the FBI to tax gun purchases. Well, the president didn't like that amendment, but because it was a little bitty amendment in a huge, gargantuan spending bill, he actually signed it into law. So basically, the new restriction now said that the FBI has no money to enforce a tax on gun buyers. I mean, think of it, because even though it started small, that would be a great way. If the FBI could get that started, then it could be raised to huge amounts later, and therefore make it very difficult for people to. I mean, imagine, if you're buying a firearm and the tax is like 1,000 or 10,000% of what the gun costs. I mean, that would be a way to effectively deny people their Second Amendment rights. So here, you look at the separation of powers at work. The president tried to do something that was unconstitutional. There was no authority for it. He tried to tax gun buyers, and the Congress stopped him. They didn't have to go through a long impeachment process. They didn't send, have, big long hearings and things like that to stop him from doing that. No, the Congress just said, Mr. President, there's no more money to tax gun buyers, so you have to cease and desist. And guess what? That restriction is still the law to this day. It is still the law. Take another example. This is something we talked about recently. Remember the light bulb ban? What's up with that? But well, Congress actually defunded this ban. They cut the funding for enforcing this ban back in December of 2011. So the law is on the books, but there's no money to enforce the ban. So that means these light bulbs can still be made, even though they're technically against the law. You know, they were phasing them out because Congress defunded the enforcement of it. That frees manufacturers to go ahead and still. Oh, very nice. They turned out the lights on their plans. I like that. Anybody want to add something to that? Kind of keep it going? No? I mean, some of you are saying just what's the difference? I can't use what's again. I already used that. So, well, Julia, nobody else is adding to that. So, I was just going to go there. They're in the. Oh, you beat me to it. Flipping the switch on a round of puns. Now, back to our regularly scheduled program. So we looked at the legislative and the executive powers. We've looked at the tug of war that they've just unplugged. There we go. We've looked at the tug of war that takes place. Now let's look at Article 3, the judicial power, right? Judicial power. Do you know of any famous judges? I mean, there are famous judges today. You know any famous ones? Some of them are on TV. How about Judge Judy? Yeah. Judge Janine. Oh, we have a Fox News viewer, right? Judge Janine Pirro. Yeah, they got a bunch of them, you know, divorce court and all kinds of things. But anyway, she's not the only famous judge that I'm sure you're aware of. I mean, how about Moses? Moses was a judge, and look at those ripped biceps he had, man. I mean, you know, he was doing push-ups and crunches out there in the desert. Yeah, let my people go. You know, Moses was a judge, and he understood the nature of judicial power. Was Joseph a judge? Was Joseph a judge? I guess to a certain degree he did exercise judicial power, but I wouldn't say that was his chief job. He was more of an administrator. Would you say that judges are more likely to read the Constitution than lawyers? Well, all judges are lawyers, so more than average lawyers. That's a tough question, Daniel, because what typically happens even for judges is they don't necessarily read the Constitution. They read the court precedents. They read court cases about the Constitution. So they might actually read bits and pieces as quoted, but it's always with the spin. You know, it's always with the previous court spin on it. So, you know, you might have a court talk about the First Amendment, but then it says the First Amendment means separation of church and state, which is not mentioned in the First Amendment. Okay, not a problem, Sierra. Just remind me at the end of class. All right, so let's talk about judicial power. So how did Pharaoh exercise judicial power? Well, you remember Mark said, you know, he heard the complaints of those who were challenging the law, or he got very close to saying that anyway. So they were challenging the law, or they were challenging the enforcement of the law. That's what a judge does. They listen to complaints about either the law or how the law is being enforced, right? So in Pharaoh's case, there was no separation of powers, right? I mean, the judge, that is the Pharaoh, was the same guy who made the law. He was the same guy who enforced the law. So he was exercising all three powers. He certainly wasn't looking to the rule of law because he was making up the law as he went along. But you know what? Moses was not like that. Moses was not like that. Let's read Exodus 18 and see his attitude on this. He's talking to his father-in-law, and he says, whenever the people have a dispute, it is brought to me, and I decide and inform them of God's decrees and laws. Now, I want you to notice something. First of all, the people brought their controversies to Moses. So Moses didn't go after them. They brought their complaints to him. So that's one important aspect of judicial power, is it doesn't act like executive power. It doesn't go arrest people. It waits for the controversy to be brought to them, right? And then secondly, he's telling his father-in-law that he tells them God's law. He tells them what the law is. In other words, he doesn't make up the law, right? Judges don't exercise legislative power. They don't make the law. The courts are to interpret and apply the law. They're to apply the rules and the laws that already have been passed. But frequently what we see is that judges come up with their own rules, or they twist the law and interpret it as they would like the law to read. I mean, let me give you an example of a case that occurred here in Virginia a few years back. A woman was prosecuted for shooting herself in the stomach. Okay? She was prosecuted for shooting herself in the stomach, but she was later acquitted. Now, why do you think authorities in Virginia would prosecute a woman for shooting herself? That's not typically done. You're not usually prosecuted for, like, attempted suicide. Exactly. Julia got it. This was not a suicide. This was attempted murder. Actually, sadly, it was not a mere attempt. She was successful. She was performing a self-induced abortion. She was pregnant, so she shot herself in the stomach, ironically on the baby's due date, and caused the baby to be delivered dead. It's a very sad case. She was 9 months pregnant, and she, I mean, I don't know why she didn't go to an abortion clinic. Not that that would have been better. But anyway, so she killed her baby. Well, this actually violates Virginia law. The law says that any person who tries to kill a fetus that late in a pregnancy shall be guilty of a felony. Realize that even though Roe versus Wade made it okay for abortion, and I'm using quotes for made it okay, even under that horrid decision from 1973, states are still allowed to regulate abortion in the last 3 months of pregnancy, and that's what Virginia had done. But the Virginia court decided that when the law says any person commits a felony by, killing the baby in the womb, it couldn't possibly refer to the pregnant mom. The judge said, and I quote, "Nothing in this law suggested it would have been aimed at expectant mothers." In other words, even though the law says that any person who kills an unborn baby is guilty of a felony, the judge said, oh, come on, that can't possibly apply to the pregnant mother. Well, why couldn't it refer to the expectant mom? Was there anything in the law that exempted pregnant moms from the ban on killing unborn babies? No. But the judges simply wanted to protect the supposed right to an abortion, so they twisted the law to exonerate and excuse the mom. So even though the law punishes any person who tries to kill a baby in the womb that late in the pregnancy, the judges twisted the law to suit their own interpretation. Hence, they exonerated her and they set her free. I mean, it's a very sad example of what judges do. Or what about the example that I gave you in the book in the presidential election of 2000? I remember going to bed on election night that night, and there was still no winner to the election. In fact, most anybody who went to bed that night, we thought Al Gore was going to be the winner because he was actually in the lead. But the race in Florida was too close to call, and it was all coming down to how Florida would go. It was the swing state that would decide the election. Well, the Florida election was so close, the law mandated recounts of the votes, and Florida law had set deadlines for reporting the vote tallies, and they reported those tallies in favor of Bush. He had a very slight lead. That means the election would instantaneously go to George Bush. But wait a minute. The state Supreme Court, which is made up of Democrats, wanting Al Gore to be the winner, just started making up new deadlines out of thin air. Why? Well, they were trying to give time for the state to recount the votes and find Al Gore to be the winner of the state, which would then make Gore, the Democrat, the presidential winner. Was there any wiggle room in the law for extending the dates to report the vote tallies in Florida? No. The judges were just making it up as they went along. I mean, that's, just another prime case of how judges ignore the law and will twist the law to suit their own purposes. That's an issue. Well, Julia, it's not just in Florida that that's an issue. Sadly, that's an issue all over the country. All over the country. And of course, we talked about the judges who want to ban the Ten Commandments in the courtroom. How do they do it? Well, they twist the First Amendment to mean that there's a separation of church and state that makes these Ten Commandment displays supposedly illegal. Of course, as I was just saying, First Amendment doesn't say separation of church and state. Well, in our system of government, if judges overstep their bounds, then the other branches have certain authority to check their power. Okay? For example, what could the legislative branch do if the courts are doing things they have no authority to do? For example, is there any authority in the Constitution allowing federal judges to order monuments to the Ten Commandments to be removed? Is there any authority in Article 1, Section 8? No, there's not. So what could the legislature do when a judge orders this? What could they do? There's actually a couple things that you could mention that are within their power. Appeal or pass further legislation. I'm not sure what you mean by appeal, but let's take the second one first. The question was, what could the legislature do if a judge is overstepping his bounds, say, ordering a monument to the Ten Commandments to be removed out of a courtroom when there's no authority in the Constitution to justify such an order? So Julia says they could pass legislation overriding the judge's ruling. That is one option. Another option would be impeachment. Impeachment doesn't just apply to doing it to presidents. It applies to any government official, judges, even congressmen, really. So impeachment. Now, back to passing a law. Congress could pass a law signed by the president which would overrule what the judge is doing. Let's take a look at a debate that took place in Congress that dealt with exactly this very thing. We're going to look at an example of what the Congress can do when the courts overstep their authority. And to act out this debate, and this is a real debate which took place in 2005, earlier you guys were wondering, why is Abby representing New York and Hannah representing Indiana? Well, the reason is because Hannah, you're going to read Representative Hostetler's part because he is from Indiana. And Abby, you are going to read Representative Nadler's part because he is from New York. Yes, Abby, you get to be the Democrat today. And Hannah will be the Republican. Now, just to set the scene, the debate was about a federal judge who, similar to the Alabama case, had ordered a monument of the Ten Commandments to be removed from a state courthouse in Indiana. So that's why Representative John Hostetler, he's no longer in the House, by the way, but at the time he represented part of Indiana. He introduced an amendment which eventually actually passed the House that would prohibit any money from being spent to actually carry out that court edict. In other words, his amendment says no money can be spent to have U.S. Marshals remove the monument. So effectively, it would have overruled what the court was saying, in saying take out that monument. Okay. All right. So we're going to start with Hannah reading Hostetler's part, since it was his amendment. He gets to speak on it first. Let's see. Let me bring that up. And Hannah, where's Hannah? There's Hannah. Hey, Hannah, how are you?
Hi, I'm good. How are you?
All right. If you would, go ahead and read what Mr. Hotler had to say about his amendment and what it would do.
Okay.
And by the way, sorry for interrupting. Hannah, while you're reading this, you might just be thinking about what constitutional provision or text Hostetler is appealing to in order to justify his amendment. So be looking for that as you're reading this, okay? So go ahead.
Chairman, this ruling by the Southern District Court in Indiana is not a lawful decision, consistent with the Constitution. That's why I will utilize Congress's Article I, Section 8, power of the pursue to prevent any funding from being used by the U.S. Marshal Services to remove the Ten Commandments monument. My amendment would prevent any funds from being used to enforce this unconstitutional and unlawful judgment.
Okay, so again, Hannah, what do you see there that he's appealing to justify, to support this amendment? This amendment that would basically keep all payment, or basically say no money could be used to actually enforce this court order.
I'm not exactly sure, but
all right. Well, let me throw it out to everybody else. Open it up a little bit here. Anybody else see maybe what he was referring to? And so, Hannah, just hold tight because we'll come back to you. There's going to be a little bit of back and forth between Hostetler and Nadler. Yeah, Article 1, Section 8, Clause 1, which deals with the power of the purse, which deals with funding. You know, Congress controls the purse strings. And so Hostetler is saying, look, you know, we have the power of the purse, and so we are saying, you know, a lot of times we say money can be spent for this or that. Well, now we're saying no money can be spent to do this. That's exactly what Congress used or appealed to when, you know, the gun tax I was telling you earlier, how Congress stopped the FBI from taxing gun buyers. They used the power of the purse. They said no money can be used to enforce that order. All right? So that was Hostetler's point. Now, obviously, other congressmen didn't quite see it this way. Mr. Nadler certainly didn't. So let me get Abby to read Nadler's response. And by the way, he uses a word in here, the word arrogate, which is probably not a word that everybody understands. Arrogate basically means to take or claim something for yourself without jurisdiction, or sorry, without justification. To take or claim something for yourself without justification. And so, as you're going to see, that's what he's accusing Hostetler of. But anyway, Abby, are you there?
Yes, I am here.
Okay. Oh, and by the way, Julia, thank you for printing the exact. Boy, I'm getting tongue-tied. The exact part where the idea of the power of the purse comes from. It's Article 1, Section 8, Clause 1, saying that Congress can provide for the common defense and the general welfare. So they can pay money to provide for the common defense and the general welfare, which implies that they can also say there is no money for doing certain things. So that's exactly what Hostetler was trying to do. Okay, Abby, take it away and read Nadler's response.
All right. Mr. Chairman, if Congress wants to change the law, that is our prerogative. If we want to begin the process of amending the Constitution, that is our prerogative. But in terms of interpreting what the law is, what the Constitution commands, what the law passed pursuant to the Constitution says, that is the job of the court. To fail to enforce court orders, to arrogate this body the right to say that we do not like a particular decision. We do not agree with the court's interpretation of the Constitution. We do not agree with the court's interpretation of a law that we passed. Therefore, we may not enforce the law. It is to say that we are no longer a nation of laws. It is to say that we are no longer a nation governed by a constitution.
Now, Abby, if you kind of start below the middle part of that quote, he starts giving his chief arguments against the Hostetler Amendment. What are his chief arguments why the Hostetler Amendment is a bad idea?
It just doesn't agree with the Constitution, and if that's not the case, if it doesn't agree with the Constitution, then there's no point to doing it at all, because we're, as he says, a nation governed by the Constitution.
I personally didn't get all of that because you were cutting in and out. Probably just a bad internet issues going on. But just from what I heard, it sounded like you were getting it. Basically, Nadler is pointing to the fact that, hey, look, guys, if we don't obey the court, if you don't obey the court, then quite simply, you're not following the rule of law. I mean, you're not following the Constitution, right? I mean, what do you all think of that argument? I mean, it sounds pretty good. If you don't follow the courts, then how is it that you're following the rule of law? How is it that, aren't you acting lawlessly? Isn't that anarchy? How can you say, oh, we're not going to follow what the court says, right? I mean, what do you all think of that answer? Is that a good answer? Mark says, but there's a supreme law that is the Constitution. So in other words, the Constitution should trump the judges. The judges aren't the supreme law. Use rhetoric, logos, and logos to defend an illegitimate point. Mark says, and then there are other laws. Yes. Okay, good. Now, Hostetler obviously is not going to take that sitting down, and so he rises to answer this, and so we'll bring Hannah back. And Hannah, now this one is going to be 2 slides long, okay? So I will advance the slide when you get to near the bottom. Okay, go ahead.
Mr. Chairman, the founders of this great nation foresaw the problem of courts imposing their own political views through their judgments and wrote about it. In promoting the adoption of the U.S. Constitution, Alexander Hamilton wrote in Federalist Number 78 that the judiciary is beyond the comparison the weakest of the 3 departments of power. The judiciary has no influence over either the sword, the president, or the purse, the Congress, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment.
Did it not advance?
Mr. Chairman. Oh.
Okay, there you go.
Where is it? Oh, Mr. Chairman, given the fact that the judiciary has... Didn't I already read that?
Yes, go ahead.
It is left to the executive and the legislative branches to exert that force and will. Time and again, I am sure that my fellow members of Congress are asked about unconstitutional decisions made by the federal courts, and many of us say there is nothing we can do. The answer is inconsistent with our Constitution and the vision of our founders. We can do something. Chief Justice Marshall suggested the most radical method for correcting judicial decisions ever advanced, but before or since by any man of the first class, appeals for the Supreme Court to Congress, senators and representatives to be the final judges of any judicial decision with which a majority of the House was dissatisfied.
Okay, thank you so much, Hannah. Now, either you, Hannah, or anybody else, what's his main point here? What's Hostetler saying? Mark says, I like this Hostetler. Okay, so what's he saying? What is he saying back to Nadler, who says, hey, Hostetler, you're not following the rule of law? I mean, if true, that's a devastating argument. So what is Hostetler's response? And Hannah, I'll leave your line open in case you want to take a stab at it since you've been reading this.
I'm bad at reading and getting the actual idea of it in my
Okay,
head
not a
time.
problem. No, I know, especially when you're having to deal with some words that you don't normally use. So yeah, that can be difficult. Anybody want to take a whack at what Mark says? He's saying that the judicial branch isn't meant to make laws. That's reserved for executive and legislative branch. Okay, now be careful there, Mark, because the executive department doesn't make laws either. Now, I mean, you might say they have a small part in it in that they can sign the legislation into law. So if that's what you meant, okay, it's a very minor role. Well, I guess you could say it's even bigger than a somewhat substantial role. But yeah, the judicial branch, it's not meant to do that, right? They don't make laws. He also points out, Hostetler does, that the courts are the weakest. Let me go back a slide. The weakest of the three branches of government. So where's that word? Where's my? Let me try a brush here. There we go. Can you see that? They are the weakest of the three branches of government. Well, that's very significant. In other words, they can't exercise force. He says they can't force the president or the Congress to do what they want. All they have is merely judgment. In other words, they can only give their opinion in the matter. They can't force the Congress or the president to follow their their opinions. Up here again, courts have neither force nor will. And then down here, he talks about Chief Justice Marshall. Now, Chief Justice Marshall is the guy, and you're going to read about his decision in Marbury versus Madison. His decision, people like Nadler frequently use Chief Justice Marshall's opinion in Marbury versus Madison to say, this is why the courts get the final say. And if you understand that, you understand why Hostetler is now quoting and referring to something that Chief Justice Marshall says, because Chief Justice Marshall himself said that the judges are not the final word, that the Congress, he puts it in terms of that you can have appeals. That's maybe the wrong way to say it, but that after the Supreme Court issues an opinion, you can have senators or representatives act as the final judges. Well, how would they do that? Well, they would do that by passing a law. Now, Daniel says, wait, so what can the courts do to keep the other parts of government accountable if they can't use any force? Daniel, what they can do is they can say, so let's say, let's say with health care, okay? Congress passes the bill, the president signs it and starts fining, or maybe there's people who refuse to pay the fine because they're not buying Obamacare, and so they're being either fined or, at worst, let's say they don't pay the fines and they're even thrown in jail. The courts could say, we're not going to convict you, innocent. And so if the court declares you innocent, then you are free to go. I mean, that is the one thing they can do. But the courts, if the courts say, well, let's reverse it. Let's say, let's take this case. Let's say the courts make the statement that these monuments to the Ten Commandments can't be in judicial buildings. They must be removed. Well, the courts don't have a police force that they can send out to remove the monuments. That's why Hostetler, actually, that's why Alexander Hamilton in the previous slide was saying they have to depend on the Congress or the executive department for the, let's see, maybe it was over here. No, maybe it was back on the previous. Where does he say it? In promoting, no. Just he has no pen. It can take no. May truly be said that neither force nor will nor judgment. It is okay right here. It is left to the executive and the legislative branches to exert that force or will. So the judges give their opinion, and therefore they just have to rely on the other branches to say, you know what, those judges made a pretty good argument. Okay, we're going with that. All right. So that's why the founders, though, believed that the courts in the end would be the weakest of the branches because they can't enforce their opinions. It's ironic that in some ways we've almost turned the courts into the most powerful branch because we've given them the final say on what the Constitution means, and then everybody else just sort of rolls over dead. That's very dangerous. Now, that's what Hostetler says. Obviously, Nadler is going to have an answer to that. So let's have Abby read what the answer is. Go ahead, Abby.
Mr. Chairman, no member of this House who believes in this rule of law should vote for this amendment. The subject matter on which it is specifically aimed, the particular decision of the court, is not relevant. When President Eisenhower was faced in Little Rock, Arkansas in 1957 with the question of sending U.S. Marshals to enforce the decree of the court in desegregating. Yeah, that. Desegregating Little Rock High School. He did not approve of that decision. His biographers tell us he was not happy with it, but he sent in the U.S. Marshals because of the law as decreed by the courts, as passed by Congress, as interpreted by the courts, must be enforced. This amendment should not be agreed to. Mr. Chairman, I reserve the balance of my time.
All right. Thank you so much, Abby. So notice what Nadler's view of the Supreme Court here is. The law as decreed by the courts. In other words, the courts get the final say. By the way, the example he gave there, desegregation, it used to be in the school systems that blacks and whites could be kept separate. Okay, that's what the word segregate means. But in 1957, the court said you can't do that. So you have to desegregate the schools, or put it more simply, you have to integrate the schools. You know, have blacks and whites attending the same schools. Well, the governor of Arkansas didn't like that, Mr. Nadler is pointing out, but he recognized that the courts have the final say, so therefore, even though he didn't like it, he obeyed the courts. Now, there is a hypocrisy to all this, because Nadler says that the Supreme Court is the final word, but really what he means is the Supreme Court is the final word only when it agrees with him. And you will see in Chapter 6 that liberals like Nadler will oppose the Supreme Court whenever it disagrees with them. So as long as the court agrees with him, then hey, the court gets the final say, rule of law and all that stuff. But if it disagrees, if the court disagrees with what he believes, then guess what he does? He works to overturn the court's decision. And I show you an example of that in Chapter 6. And so, you know, when you see that, I hope you say, man, what hypocrites these guys are. Because all this talk about rule of law and courts get the final say, but they don't apply that across the board when the court goes against them. So get your economic sniffers out. Did I say economic? Your hypocritical sniffers out and look for that when you're reading Chapter 6 this week. Anyway, so thank you to our readers, by the way. Abby and Hannah, thank you so much. We've talked about how the Congress can rein in the courts. And again, the Congress, actually the House, passed the Hostetler Amendment. Sadly, the Senate didn't concur, so it never became law. But they could have, and Bush probably would have signed it because this was back about 10 years ago. Anyway, that's one avenue for the Congress to rein in the courts. But there are other ways to rein in a runaway court. And let me give you that example. This is one thing we've already talked about in passing, uh, but in our federal system of government, when I say in passing, the South Dakota example, I'll flesh that out in a second. But in our federal system of government, the states, as you know, can check or rein in the federal government when they step outside of their authority. And the South Dakota example is a perfect example of that. It occurred in 2006. South Dakota is the Mount Rushmore state. Let me read to you an article from this time period so you see what I'm talking about. Members of the South Dakota House of Representatives gave final approval to an abortion ban, sending it to the desk of Governor Mike Rounds. It would ban all abortions in South Dakota except for those to save a mother's life. Doctors who perform a banned abortion could face $5,000 in fines and prison sentences. The bill's backers hope it will challenge Roe v. Wade, the landmark 1973 Supreme Court decision that recognized a woman's right to abortion in the Constitution. Now, isn't this great? The state defied the U.S. Supreme Court and banned abortion because actually the governor went on to sign that bill into law. Unfortunately, this is where democracy killed a good idea, because after the legislature did that, the people in the state got this issue put on the ballot during the November 2006 elections. And guess what happened? When the people of South Dakota went to vote that November, just like Americans will be doing tomorrow in several states, the people of South Dakota voted to repeal this law. Sadly, that's democracy in action. You get the tyranny of the majority. And that is the tyranny of the majority, basically saying it's okay to murder a certain segment of our population. Now, here's the problem. Once the people have passed bad legislation, who can hold them accountable, right? It's very difficult. See, this is the advantage of having a republic where legislators pass laws and then they can be fired if they act in a stupid or unconstitutional manner. But in a democracy, there's little accountability. You know, you can't fire the voters. But in a republic, there is a greater sense of checks and balances because there is a check on the tyranny of the majority. Now, we're at the end of time, so let me go back over the homework because I know I've gotten some private chats, at least one, as to this being a little confusing. In your homework, you're going to be looking at some state laws that have resulted in the closing of several dozen abortion clinics around the country. So you'll be using these laws as a springboard, not so much to write about abortion itself, but to answer legislators' objections about the constitutional issues surrounding the abortion debate. So these laws basically require what the states are doing. They're passing laws requiring abortion clinics to have the same safety standards that you would find in a hospital. And they're resulting in clinics going out of business because these abortion mills are gross and they're disgusting and they don't have the money or don't want to spend the money to upgrade their safety standards. But because these places are going out of business, guess what? Babies' lives are being saved. So as part of the article that you're going to read, you're going to see after North Carolina passed its new regulations, the Asheville Clinic became the latest closure as it failed to pass the newly enacted rules for basic safety and cleanliness with health conditions that put patients at risk. The 42 clinics that have been closed to similar violations, blah, blah, blah. Texas and Pennsylvania enacted similar laws. Anyway, proponents of these laws, you can see they're trying to save babies' lives, and that's what's happening. But whenever you start talking about a law like this, opponents appeal to Roe versus Wade, and they say, oh, the Supreme Court already settled this issue in 1973. You can't pass laws like this. You can't limit a constitutional right. And so what your assignment does is it gets you to answer these common objections to laws like this. And so that's why you're going to be focusing on these 4 points. Why Supreme Court decisions like Roe versus Wade are not the supreme law of the land, right? Why the court is not the final word, right? It's not the final word. You also are going to give historical examples. That's number 3, showing how the states can interpose themselves, how they have done it. And then finally, number 4, you're going to give constitutional arguments showing why the states can do this. And on that number 4, don't forget to connect the dots and explain why the constitutional provisions you've chosen actually allow the states to interpose themselves like that. So again, you'll probably have 6 paragraphs. An introductory paragraph, points can be a separate paragraph, and then your concluding paragraphs in all. No problem, Logan. So does that make sense? Does that help clear up because what you're going to be doing? You know, today what we did is look at the 3 powers of government. We saw that only God can exercise those 3 powers without abusing his power and becoming tyrannical. And the very definition of tyranny in our founders' minds was having all the powers in one place. Obviously, Pharaoh was an example of that. Unlike Pharaoh, in our system of government, there's no one branch of government that gets the final say. And so you're going to see that over and over, that not even the courts get the final say. Sierra, does that make sense to you? Because I know you had asked about that. I can give you the mic if you want, if you've got something specific you're confused about.